Hi friends, today is the day with the guns. Bang, 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 yes. This is enforcement. So enforcement, you have traditionally criminal enforcement, right? You have the civil enforcement and you have administrative enforcement. So I will not go about criminal enforcement. That is up to the member states. There's no harmonization. There is no one rule within the single market. Every country has its own tradition with regard to criminal enforcement, so that is out of discussion here. Civil enforcement is the one I will take into account, and a bit of administrative enforcement. But let me put one thing clear. Administrative enforcement, the EUIPO is out of the game. Not, well, it's different in some countries, so therefore I mention it. The EUIPO is the managing agency for the trademark system in Europe, but it has no enforcement capacities or competency beyond the fact that they can manage the registry, meaning that they are able, being seized, to delete or to reject, so to say, one trademark or the other, but they cannot enforce the trademark law in beyond that. So therefore we have IPRED. IPRED is the IP Rights Enforcement Directive. So very quickly, the directive is a legal instrument and a regulation is an legal instrument. Both of them are used by the Commission in order to make, so to say, the European law palpable and going live. So the regulation is something like the trademark regulation or trademark implementing regulation, which is directly applicable in each member state once the Council, European Council, or the Parliament has decided upon it, had adopted it. Now the directive is a bit different. Once the member states are clear, they make a regulation. If they are less clear, though, well, we have some minimum standards, but I don't know, I will doing this and I will doing that, then the member states, the Council, which are the member states, they would choose a directive which gives minimum standards, and beyond the minimum standards, each country is doing what they want to do. But the minimum standards have to be adopted. But it is not directly applicable because it has to be transposed into the law of the member states first. And there are some years, so in order to do so, 3-4 years, and then afterwards the national law is applicable, although inspired by the directive. You get this? Okay. This is a directive. IPRED is a directive, so it has been transposed into the law of the member states. That was adopted in 2004, and then in 7 or 8 or 9, then it has been transposed into all the national law of the member states. And there are 6 main issues, so to say, and here is the summary of it in that table, where you can see what were the 6 objectives of the IPRED, and I will go into each of them. Just one thing before, the IPRED is applicable not only to trademarks, but to a variety, to all of IP rights. So is that the right way to tackle it? I don't know. Well, it is the case what it is. IPRED was adopted in 2004, I say, and as with many things in EU, after 10 years you want to see how is it functioning. Was it okay to be adopted, or what kind of modifications we need to do in order to be efficient, right? So that was in 2014 and 15, 16, there were some studies ongoing, and the last comprehensive document of the review of IPRED was being done by the Commission in 2017. And this table you have seen just a moment ago, that is coming from that study, or from that resume, the result was that there are some deficiencies to be done. I put you at the end of the presentation. I will put you the link, so for those who are more interested to go into detail, they can do so. Now, what happens with the enforcement? Enforcement, you need probably to have a lawyer in Europe in order to be able to be actionable with regard to enforcement in Europe. And the lawyers are still nation-wide organized, meaning that the German lawyer acts in Germany but not allowed to act in France, and the Italian lawyer is not able to act in Greece. Probably not only not able, but he has no competency. He doesn't know the Greek law in order to be, efficient and actionable in favor of their client. So you need a lawyer in Europe, and you have to choose the lawyer a bit with regard to, your action radius. You would not choose probably a lawyer in Greece because I don't know whether you have your main problems in Greece, but often that is not the case, or in Malta or in Cyprus for that matter. So you want to have probably also an international law firm which is able to have possibilities to act in Paris and in Berlin and in London at the same time, because they have one law firm which is, linked to different countries. But you want to have this lawyer being established, right? So let us go through the different steps now. The easiest way, or the special way, the most special way, I would say, whether you go with enforcement, would be a border seizure, which is possible with regard to an investigation you have carried out before. So if you know that infringing goods are entering the port of Rotterdam on that day in that container with that ship, etc., it is not probable that you get this information, but it may be possible. So then you would go to Rotterdam to contact the customs and give them the information, and then the customs would seize the goods. If the facts are established, they would seize the goods, and then afterwards it is up to you to make the corresponding court rulings happen to either destruct the goods or sell the goods or get the goods, whatever it is, right? So that would be a heavy investigation before, and probably also a heavy cost upfront paid by your client. So that is not the current case, but I want to mention it because it is possible that you get this. So you would start probably with a cease and desist letter, right? That is a letter from your lawyer, probably from your European lawyer. I would recommend to take a European lawyer to the other party, either his lawyer, her lawyer, or the party itself, by saying, well, we have seen this infringement is happening, right, and we want you to desist from continuous infringement, and if there is infringement in the future, then you would agree to pay a fine of, 500,000 euros, a heavy sum, right? So that would be a cease and desist letter, and if it is signed by the other company, a cease and desist letter, well, you are quite, you're good, right? It is a cheap measure being taken by you. It is only a short letter. It could be 1 page, and plus the agreement to be signed by the client returned to you, and that's it. So you have leverage for the future, so you know that they probably will not do anything bad for the future. Now, if not, then you are in some kind of strategic considerations. You need to decide about which court to go, in which country the court to go. So you would have to take into account what is the the tradition in each country for the damages. If that country is being known for issuing low awarding damages, then that is not good. The seizure of the goods, where are the seizure of the goods? If you can seize afterwards, if you win in court, you want to get paid, right? So where are the goods, in which country? Or you want to know which are the application, which are quick, which are slow. You want to go to certain IP courts within the country. Why IP courts? Well, they are quicker in decide, and they are more knowledgeable with regard to the issue. So these are all, or if it is a cross-border case, so you want to know in which country you can easily enforce a ruling you will get. So if you get a ruling in Germany, is it easy to enforce in, I don't know, in Portugal? You have to look at these things. So to look at the end. Or if you dealing with a bankrupt company, you don't care about the seizure anymore. So these are considerations you have to take into account from the beginning. Now, IPRED makes it possible to make an interlocutory ruling. That is now possible with IPRED. Now, interlocutory ruling are in some cases are doing very well because they have a tradition of interlocutory rulings. Others, they are more hesitant. But interlocutory ruling is an efficient way in order to get, for example, a seizure of the goods, or to get certain documents or evidence secured for afterwards ruling, or to whatever it is, an imminent damage to be done, freeze of funds, for example. So that is possible, and you will get a ruling within short time. That can be as short as 36 hours, 48 hours, 72 hours or so. In Germany, that would be the case, from the special court, which are dealing with IP very frequently. So that would be this one. Then the main court. So if you have an interlocutory ruling, then it is more often than not a final ruling, because you get to a settlement on one way or the other, because the cards are already on the table. You have the judge who also may be willing to enter a bit into the discussion of a settlement. So if you get a settlement, okay. If not, you have to pursue main proceedings. You're not necessarily in the same court, but in another court, but you have to pursue the main proceedings. And again, those strategic considerations with regard to the main proceedings, right? Punitive damage. We're coming now to damage. I'll speed up because I don't want to go much over time here. So the punitive damage. Punitive damage in some countries exists, right? In other countries, they do not exist. In Europe, generally, it does not exist. The IPRED has minimum standards, so each country could have introduced or maintained punitive damage as in the past, but there's no big tradition in it. Germany and France, for example, they have explicitly prohibited punitive damage in their law, and other countries like Italy, for example, they have a neglect, willful and a strong willful premeditation infringement, where you can go a bit beyond. On the damages, there is nothing very astonishing, but some particular issues as well. So the damages, as I said before, there are some countries which are more prone to give high damages, and others they are reluctant to go higher. And the damages are the lost profit of the rightful owner, right, and the undue, so to say, the undue profit from the infringer. And there is a certain issue which IPRED says moral standards, moral damages can also be taken into account, but this is more for individuals, and this has not been applied by the judges across the member states very much. So you are rather lost with these two. Now, what happens with reimbursement of the legal costs? That is an area Another issue, which is in IPRED, which is in the table I showed you beforehand. So the reimbursement of legal costs has not been done in all countries, therefore IPRED was necessary. But what are legal costs? Well, that is not defined in IPRED, so it has to be interpreted nationwide by the different judges, so by case law, etc. If there's not a big tradition to put everything into legal costs, they would not be. So the legal costs expertise, for example, or investigation, I mentioned beforehand, the investigation are very expensive, or witness statements, or I don't know, the expertise of if something has to be, that can be very, very expensive here, and more often than not, it is not included in the legal costs. Now, the public ruling, that is the last issue in IPRED. The rulings on enforcement, they should be, publicized all over. But this is not really the case. There's the language issue as well. So there are some, it may be also that is something the Commission was more interested in than the users, by saying, well, if you have all the rulings, I can easily accessible and I can compare one and the other, and I see whether it is necessary for me to act on the enforcement directive again, or to issue a new one in order to higher the standards or whatever. But complementary to this, you have at EUIPO an enforcement database, which is possible where significant national judgments have been publicized, so that could be a possibility as well of you to go after it. Now, is the enforcement everything okay in Europe? Probably not, right? Probably not. There's room for improvement, I would say. And I would think that the Commission is on it in order to make some modifications for the future and make this more efficient and more harmonized in order to get to its point. Well, what is it? Yes, you know it, the single market, right? You want to go to the single market, and that would be one thing. Well, the single market should be equally on cost distribution, etc. And that would be a manner to come to that. So I'm over time. Thank you for tuning in.